Ladies and gentlemen, welcome back to the IndieZoNe. My name is Kathy. On this date, the 28th of October, 2025, the court released 3 documents onto the court docket dated the 24th of October. State's response to defendant's objection to request for restitution. Let's look at the state's response first. Now, the state had done what we had predicted that they were going to do, which in this response, we had predicted that they would file a document under seal, and they have. The exhibit that the court went ahead and sealed from the public. This document, state's response to defendant's objection to request for restitution, is much lengthier, however, than the September 22nd original filing seeking restitution, which was just a page and a half and contained a 17-page exhibit that the state asked to be filed under seal, and that was filed under seal. In this response, the state raises the fact that it acknowledges the Rule 11 plea agreement was filed herein, and then regarding restitution, under Section 4, the agreement states, the state may seek restitution orders regarding funeral expenses and crime victims' compensation reimbursement in an amount to be determined. Then it says and going on to page number 2 of this filing, at the time of the plea agreement, the state was under the impression certain expenses incurred by the victims' families would be covered by the crime victims' compensation, and after the sentencing hearing, the state was informed by the crime victims' compensation will not cover travel and lodging expenses for attendance of court proceedings. And on behalf of the victims, the state submits the itemization of expenses that were incurred by the victims' families, including expenses not covered by crime victims' compensation, for the court's consideration. See State's Exhibit 1. That's the document under seal, ladies and gentlemen. The state is affirmatively advocating for payment of funeral expenses as itemized by State's Exhibit 2, pursuant to the plea agreement, also under seal. So if we could interject a comment, an opinion here. First, it appears that the state is owning up to the fact they made a mistake. They thought the crime victims' compensation fund would pay these expenses, and that's why they were not included in this prior agreement that the defense raised in their response opposing any additional compensation. You can read that document. It's filed October 7th. What the state's saying here is they had the mistaken notion that it would be compensated from this fund, and they found out that at the time of sentencing this was incorrect. So if I could throw out a rhetorical question, the time of sentencing was July 23rd, 2025. They filed their request for this additional restitution almost 2 months later, September 22nd. So the question rhetorically is, why did they wait almost 2 months to then come forward and correct this error that they learned was an error on July 23rd? They're saying here this happened at the time of sentencing. Why didn't they immediately file something? The state goes on and argues that the defense argues the requested restitution should not qualify as direct economic loss since the victims' families received third-party donations. And then the state points out, hey, under Idaho Code Section 195304 in controlling precedent, directly injured victims may receive full restitution despite third-party payments, unless those third parties qualify as statutory victims through contractual obligations to pay. And then citing to an Idaho Supreme Court case, this is State versus Cheney from 2007. So now applying this legal authority to the facts here, this is what the state's doing next. They're saying, applying the Cherney analysis to this case, charitable donations, such as those received through GoFundMe, arise from voluntary generosity rather than legal obligations. They're saying here the people who donated to GoFundMe, they didn't have a contractual obligation to do so. They did it out of their own generosity, is what the state's saying here. Since charitable donors lack contractual obligations to pay victims, they cannot qualify as statutory victims under Idaho Code section, and then gives the section of the statute. Therefore, their payments do not reduce the defendant's restitution obligations to the directly injured victims under, and the statute is cited again, this is also supported by public policy considerations, focusing on making the victims of crime whole for a defendant's criminal conduct, rather than accounting for victims' good fortune in receiving community support. And now state cites to other legal authority for this proposition, State versus Schultz. This is a 2008 Idaho Supreme Court case. Next page. Lastly, the defendant argues that restitution should not be awarded based on defendant's ability to earn money or pay money, given his 4 consecutive life sentences plus 10 years. And that comes directly from the defense's objection. You can find it at page 4 of that October 7th document to read it in its entirety. Now the state turns to Idaho Code section, and the statutes given provides clear authority for courts to order restitution from life sentence defendants. And then turning to this point that the defense raised, hey, Mr. Kohberger's a lifer, 4 consecutive life sentences plus 10 years. He's not getting out. He's got no ability to pay. But the state now counters. The immediate inability to pay restitution shall not be in and of itself a reason to deny restitution. And now citing to State versus Bybee. This is an appellate court case, Idaho, 1989. While Idaho law permits restitution orders for life sentence defendants, courts retain discretion to determine whether restitution is appropriate in individual cases. So this is a court applying the court's discretion to come up and to determine, hey, can Mr. Kohberger, pay this, not pay it? And then they go on and say, this is a case that is very high profile, sort of inferring to the fact in the next paragraph, this case has and will continue to attract worldwide attention, which could result in the defendants prospectively receiving money subject to interception by the state treasurer pursuant to and then the statutes given. Restitution orders may be recorded as civil judgment and should be collectible from any monies prospectively deposited in escrow with the state treasury. So saying maybe he doesn't have the ability to pay right now, but maybe sometime down the line. Look, this was a very high profile case, and Mr. Kohberger has said very little. He's basically spoken 2 times, 3 times possibly. First appearance, when he pled guilty, and he spoke very little, yes, no. So there may be an offer down the line of an interview. He may have already received offers for interviews, paying offers, or opportunities to write a book where money could be paid to him. Sometimes defendants in prisons, they sell artwork and they sell other things. So this is the issue that the state has come back with. Now we see here the motion to seal the exhibit and the court order sealing it. So the exhibit that's attached to this motion, just like the filing back in September, is under seal from the public's review. Now I had predicted all along, and having read this document, I am predicting again, this is a rhetorical issue. This is an opinion. It's speculation, but I anticipate the defense is going to file a reply in opposition here prior to the hearing on November 5th. If and when the defense does file a reply replying to this response, we will, of course, advise you. These documents are currently available on the court docket in Idaho versus Kohberger for you to review. If you have any comments, thoughts, opinions, please leave them here. Until next time, this is Kathy. Thank you for joining us here today.